Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're doing a video all about anterior cervical discectomy and fusion, ACDF, injuries resulting from car crashes in New York. So these are cases about New York, New York City, the Bronx, Brooklyn, Manhattan, and New York State as well, up in Buffalo, Rochester, all over New York, Syracuse, and it's car crashes. So they could be any type of auto accident. Could be a car crash, pedestrian knockdown, bus accident, motorcycle accident, truck accident, any type of automobile, motor vehicle accident with a anterior cervical discectomy and fusion. Could be 1 or 2 levels. And so I'm doing it through some of these research databases that I have, and they allow you to search either by injury or by type of case or both. And I'm going to do a deeper dive where I can actually explore all the different options and then do different videos, because I just realized now from searching, you could actually do very specific searches, like for example, only a 1-level fusion at a specific level like C3, C4, and only a specific type of case like a ceiling collapse or a lane change car crash, only a lane change. But I don't know if that's really going to give you any additional insight, because it's not like a C3, C4 injuries is worth any more or less than a C5, C6, so that's, I think it's, that doesn't really matter. But let's get into it. And I have my, coffee here. It's in the morning. I'm still in the state of Washington. I'm actually going back to New York today. I'm here for a trial lawyers college continuing legal education, where trial lawyers learn more on how to connect with juries, on how to find the universal truth in cases. So it's very good. And actually, I didn't have my breakfast. I skipped my breakfast to do this video for you guys because I love doing videos and helping people. So I actually popped some popcorn. So I have popcorn for the show. The popcorn is just for my Airbnb, but it's actually very, very good, preservative free. So I'm gonna have a little popcorn and get into it. So let's actually start with, we could sort it by, there's a few different ways to sort it. One of the ways to sort it is by highest amount. So maybe let's start with the highest amount. I know people like big verdicts, big numbers, to see that what's possible. And then we could resort it and we could do it by most recent to see what's happening now. So this particular search I did returned 550 results. So there's a lot of cases, in New York. And so this specific one, the lowest amount was, I guess there were some that were probably 0 defense verdicts, but according to these averages, one of the lowest ranges is 25,000, and the highest range towards the upper echelon of the ranges is 12 million, and the average is 1.465 million for this search. And like I said, this search is ACDF, fusion, 1 or 2 level, plus any type of car, bus, motor vehicle accident. So here's a case. Let's look at this case. This is an interesting case. And the cases are very, very detailed. So I'm not going to be able to tell you everything about the case because they're very, very detailed. But I'll try to get to the heart of the matter. I'm going to see what I learned from this trial lawyers college and see if I could get to the heart of the matter. Okay, so here's one case. And this case was a bus passenger. And the bus was involved in a crash. So what happened was a 41-year-old individual who was a street vendor and another lady, a 41-year-old unemployed lady, were both passengers in a transit bus. And the bus was being driven by the bus driver, who was traveling in the southbound side of a street in Brooklyn, Nostrand Avenue. And so what happened was the bus struck the rear end of a truck that was stopped on Nostrand Avenue. And so the male plaintiff, his name was Musa. He actually claimed that he suffered injuries to his back, knees, neck, and shoulder. And then the lady, her name was Shirlene, she claimed that she suffered injuries to her back, knee, neck, and shoulder. And so they both sued the bus driver and the owner, which is what you do in a car accident or bus accident case. You sue the operator and the owner, and it's known as owner-operator. And so here the bus driver was an employee of the New York City Transit Authority. They run the buses and the subway systems, as well as the Manhattan and Bronx Surface Transit Operating Authority. So that's another company that runs certain buses in Manhattan and the Bronx. Now, this particular crash happened in Brooklyn, Nostrand Avenue, but I guess maybe the route took this bus to the Bronx or to Manhattan, and it was part of that MABSTOA entity. What happened was the plaintiff moved for summary judgment. And like I talked about before in other videos, summary judgment just means that there's no question of fact for a jury to decide. There's no question or issue for a jury to decide. Here, the truck was stopped. The bus rear-ended the stopped truck. The two plaintiffs are passengers. They're sitting on this bus. They paid their fare, sitting in their seats. Who else could be at fault, right? It's got to be the bus. The bus just rear-ends the stopped truck. So there's no question for a jury to decide, because juries decide factual questions. And so because of that, the trial proceeded to damages. And the lady actually negotiated a pretrial settlement of her claim. And the New York City Transit Authority agreed to pay the lady, Charlene, agreed to pay her $50,000. And so that case was settled. So then the trial proceeded only as to the gentleman. His name was Musa, just him, right? They're both 41, so only him and his damages. So his injury was, he was put in an ambulance, he was transported to a hospital, and the hospital was in Brooklyn. He claimed that he was suffering pain from the left side of his torso, and he underwent minor treatment. And then the MRIs found that he had herniations, 2 in his neck, 2 more in his lower back. And he had a bunch of bulges too. And he also claimed that he suffered derangement of his knees and derangement of his left shoulder and a contusion of his left shoulder. And so he had about 2 years of conservative treatment that included acupuncture, chiropractic, physical therapy. And during that first month, the treatment was typically rendered a total of 3 times a week. And then its frequency gradually decreased, right? So then he was going 3 times a week. And then as time went on, he started going maybe just a few times a month. And so he had, the pain kept going up. The pain was not going away. So he underwent surgery that included a discectomy, and that involved excision of a C5, C6, and C6, C7 discs, and a fusion of the corresponding levels of his spine. And then after that, he had pain-killing trigger point injections, as well as epidural injections of steroid-based painkillers. And so he also argued that his back and neck remained painful, stiff and weak, that he suffered a residual loss of each area's range of motion, and that his residual effects hinder his ability to do basic physical activities like bending his torso, kneeling, lifting objects, and playing with his children. His treating orthopedic doctor gave the opinion that Musa will require further fusion of the spine's cervical region, and the doctor gave the opinion that Musa will require fusion of L4, L5, and or possibly L5S1 as well. And so he already had the fusion in the neck, and now the surgeon who did it said, but you know what, because of these herniations in the lower back, later on, he's gonna need another fusion in the lower back. That's a common thing. The other thing that a doctor could say is that because you had a fusion, let's say at this level, like C5, C6, and C6, C7, there's something known as adjacent segment disease. So now the adjacent, or the segments next to it, like at C5, C6, the adjacent one would be C4, C5. And at C6, C7, the adjacent one would be C7, which goes to T1. That's the last one. T is the thoracic or mid-back, C is the cervical or neck, and the C7, T1 is the last cervical disc. So the point is that, because adjacent segment disease is a medically known issue that just happens, then you would need, medically, you could say with a reasonable degree of medical probability, I will need another fusion above and below these levels. So, I don't know if they did that. It doesn't say, but that's another thing they could have said, because like one fusion is maybe 100,000, and plus all the pain and suffering, which is, could be in the millions. But now you need another one right at C4, and you need one at C7. So now it's like another 200,000 for the cost of it, because you're going to need it, like medically, maybe in 10 years, maybe in 20 years, but it's going to happen medically. And plus the additional pain and suffering, because now you've had, possibly two additional fusions on your neck. You've already had one, and one on your lower back, like we just read. So yeah, so that's pretty serious. Now, he also said that he was treating with a pain management specialist, and the pain management specialist in court at trial gave the opinion that Musa requires a lifelong pain management regime that could include implantation of a device that provides pain-relieving stimulation of spinal nerves. So that's a spinal cord stimulator. And then he also sought recovery of future medical expenses, damages for past pain and suffering, and damages for future pain and suffering. So the lady, the one who settled for $50,000, she claimed that she suffered sprains and strains, left shoulder. She also claimed that she developed radicular pain that extended to her left shoulder, so that's radiculopathy. And she had, let me see what else she had. She had 4 months of physical therapy, and she also had pain management. So she also had some kind of injections or pain management treatment. And she claimed ongoing pain. And so, but her case, like we said, settled for $50,000. So then what did the defense argue? So the defense started arguing that Musa did not suffer a serious injury as defined by the no-fault law, which is 5102D. And they argued that the bulging and herniated discs were degenerative, meaning from the normal, painless aging process, living your life, and that they predated the accident. So he had them before. And they also said that 2 weeks passed before Musa reported any injury to his neck or back. So I guess when the crash happened, he went to the hospital. He didn't complain about his neck and back, but 2 weeks later, he started complaining. So they said, wait a minute, how come, if you would have been hurt your neck or back, you should have complained earlier. That was the defense argument. And then the defense counsel also argued that Musa achieved a good recovery, and that Musa's back and neck exhibit full range of motion, and that he does not require any treatment. So then the trial was a 2-week trial. It was in Brooklyn. It was before a judge, a lady judge. I know her, I've appeared before her. She's decided motions, and also I've never been on trial before her, but she's a very, very nice judge. I believe her entire family are judges. Maybe her father was a judge as well. The jury was 3 men and 3 women. So we have 6 jurors in New York. So let me tell you what the result was. So the jury found, the first question was whether Musa suffered a serious injury. That's always the first question, right? Because you have to show a serious injury in order to recover. So if it's not a serious injury, you get 0. So the jury found that Musa did suffer a serious injury. It determined that he suffered permanent consequential limitation of a use of a body organ or member, and that he suffered significant limitation of a use of a body function or system. Though it also determined that he did not suffer a medically determined non-permanent injury or impairment that prevented his performance of substantially all of the material acts that would have constituted the usual and customary daily activities of 90 or more of the first 180 days that followed the accident. That's a mouthful, right? And that kind of language is what's in the statute. That's why a lot of people ask me, hey, how much am I going to get? And I say, look, there are 9 different categories of how you can prove serious injury. What I just read are only 3 of them. And the way that the statute is written by the legislature is very, very boring, right? People don't speak like that. But basically, to break it down for you, it's really simple. It's just whether you have a permanent injury, and consequential, meaning does the injury have any consequence? Does it have any effect? Is it like serious, consequential? Or is it inconsequential? Inconsequential means like, who cares? It's inconsequential. Let's just throw it out, right? It's frivolous. So as long as the injury is permanent and has consequence, and you have limitation of some part of your body. They call it a body organ or member. What is a body organ or member? Basically like a neck, right? Anything. So then the second part is significant limitation, whether the limitation, like range of motion, let's say I can't move my neck, or normal range of motion is 90 degrees, but I can only move mine 70. That's a 20-degree limitation, right? So is that significant? Sure, 20 degrees, that's a lot. That's 20% of the ability, or maybe 30 degrees, 30% of the ability to move my neck, which is 100%. So that's a 30-degree limitation. Sure, that's significant. So it's up to the jury to decide that, but that's all it is. It's pretty straightforward. And then the final one is whether you can't do what you usually do, for 90 out of the first 180 days. So basically 3 out of the first 6 months, do you not go to work? Do you not do what you normally customarily do? And they actually said no. They said he could do what he usually does. So then let's break down the verdict. So then they had to, so they said yes, that he did have a serious injury because he met those 2 categories. So now the question is how much? So they gave him, for the past pain and suffering, the verdict was $4,500,000. For the future medical cost, and they estimated the future medical cost to last 29.2 years, according to the pattern jury instructions and the life expectancy averages or tables. And they said the future medicals are $2 million. And then this was the final category, the personal injury, the pain and suffering for the future. What is it worth for 29.2 years of future pain and suffering? And the verdict here was $21,200,000. So the total verdict in this case was $27.7 million. So an excellent verdict, an excellent result. And I actually know the trial attorney. I've worked with him on a few cases, where I've been to his office, we've chatted before, and not recently, but a few years ago, we actually worked together on a few cases where we partnered on some cases. I hope to do that again with him. He's a very good trial attorney, and he runs a big firm in Manhattan. So yeah, so that was the first case. So let's go back and let me actually resort this, because we're already at the 17-minute mark and we've only done one case. It's hard. It was a lot of cases, a lot of information. But let me resort it by date. And when we go by date, we get the most recent one. Plaintiff was a carpenter. He was driving a minivan in Staten Island, and the defendant was operating a dump truck, and the 2 vehicles were involved in a low-speed crash that caused minimal property damage, and the plaintiff claimed neck injuries. So the plaintiff sues the defendants, and they claim that the defendants were negligent, and the matter proceeded to a liability-only trial. So this was only about liability. The plaintiff argued that the defendant failed to yield the right-of-way before entering the intersection, and also that the dump truck was moving at the time of the crash. The defense argued that the driver of the dump truck operated his vehicle reasonably, that he was actually stopped at the intersection's stop sign, and he looked both ways, and there were parked vehicles blocking his line of sight, so he drove forward a few feet to get an unobstructed view, and that he then stopped again and looked both ways. And the defense maintained that the crash occurred while the dump truck driver was actually stopped the second time. So they said, the plaintiff crashed into a stopped car, and that the plaintiff should have seen the stopped truck and avoided the crash. And so this was a case, also 3 men, 3 women. The case itself lasted 2 days because it was liability only, so it was pretty simple. The injury, they don't really get into the injury, but the injury was herniated disc in the neck with a multi-level anterior cervical discectomy and fusion. But remember, the injury was not before the jury. They didn't hear it. It was a liability only trial. And the trial took place in Kings County, which is Brooklyn. And so the demand, what the plaintiff wanted, was $1 million. The offer before trial was $125,000. And the jury deliberated for 15 minutes. And the verdict was a defense verdict, 0. And it was 6-0. So I guess the jury believed that this guy was stopped and that the plaintiff, crashed into a stopped vehicle. So that's the most recent one. That one is, like I said, January of 2024, and the accident happened 2018, December of 2018. Here's another one. This one is a passenger. November 7th of 2019, the plaintiff his name was Carlos. He was a passenger in a car traveling on Bedford Park in the Bronx. And the defendant was operating a Pelham Bay beverage truck that rear-ended the car. And so the plaintiff sued the truck, the owner and operator, and he alleged that the defendant was negligent in the operation of his vehicle and that the beverage company was vicariously liable. So that just means that, if you sue an employer, like a company, the employer is vicariously liable for the employee, for the worker, because it's in the course and scope of employment. So if you're a beverage company, I don't know, you deliver beer or whatever you do, Coca-Cola, and you have an employee and the employee is driving and the employee rents someone, it's not just the employee that's liable, it's the company, right? Because he's doing it in the course and in the scope of his employment. He's working. So that puts liability on the company. Now, if he was just driving on a Sunday, with his kids or whatever, go to a baseball game or to get some ice cream, and then he rents someone in his personal car, well, then of course his employer is not liable. So plaintiffs also moved for summary judgment, and that was granted because it's a rear end, there's no issue of fact. And so it went to damages trial. And this was in the Bronx. So what happened here was the plaintiff, Carlos, he was taken to a hospital, St. Barnabas. He was diagnosed also with C5, C6 herniations, as well as lumbar herniations. He also claimed a SLAP, S-L-A-P, and rotator cuff tear in his right shoulder, along with synovitis and impingement. And shortly after the crash, Carlos began conservative treatment that included physical therapy, acupuncture, and pain management. And then he received bilateral cervical trigger point injections and lumbar epidural steroid injections. Carlos ultimately underwent neck, back, and shoulder surgeries. In fact, he had an arthroscopic shoulder surgery that included a synovectomy, an acromioplasty, and debridement. That's when they shave and they remove some of the scar tissue and some of the tears. So yeah, so he had that's arthroscopic. That means they use like an arthroscope. It's almost like it's a camera. It goes in there and they could see what's happening and they clean up the tear, they remove the tear. So that was for the shoulder. Then he also had a percutaneous lumbar discectomy, and then he had a decompressive neck surgery that included arthrodesis and bone grafting. So yeah, so for his lower back, because he had herniations in his lower back, he had a percutaneous discectomy. That's where they go in with like a striker decompressor and they decompress the disc. The disc is like a jelly donut, right? If you squish a jelly donut, the jelly is gonna plop outside the donut, outside the disc. You don't want the liquid outside the disc because that jelly that's outside the disc is then touching all those nerves that are running along the spinal cord, and they run, all the way down. Like from the neck, they run to the arms, to the fingers. From the lower back, they run to the legs. And actually in the lower back around L5-S1, that's the final joint, the sacrum, you have what's known as the horse's tail. You have all these nerves. They look like a horse's tail. So you don't want that impinged. So what they did was they took the striker decompressor, they went in and they decompressed the disc. It's almost like a straw suctioning out the extra portion of the jelly that's leaking and touching the nerves. And then they made sure that the disc was a perfect circle, and then they pull out the striker decompressor. That's a minimally invasive surgery, usually done in an office. I mean, it could be done in a surgery center or a hospital as well. So then they also did this, and it was a neck surgery with an arthrodesis and bone grafting. So that's a full-blown fusion, an anterior cervical discectomy and fusion. And so Carlos also sought recovery of $75,000 in past medical expenses, and he sought damages for pain and suffering. And the defense's spinal surgery expert was going to give the opinion that Carlos's claimed injuries had healed and he required no further treatment. And so, like I said, this case was in the Bronx, but the case did not go to a full trial. It actually settled. And so the defendants, let me tell you the settlement. What happened was the defendant's insurer, they tendered, that means they gave everything they had. They tendered $1 million primary policy. And then they agreed to pay an additional amount from a $5 million excess policy. And the additional amount was $1.95 million. So the total was $2.95 million. And that was the settlement. And I also know the judge that is handling the case. He's a very good judge. I also know actually the defense firm. I've had cases with them. I don't know the defense expert. I know, of course, I know the insurance company. You'll know them too. It's a famous insurance company. If I say, like a good neighbor, that'll give it away probably. So yeah, that was the insurance company. And I know the plaintiff's economic expert, and I know the, actually I don't know the plaintiff's physical medicine expert because he wasn't from New York. He was from Connecticut. I guess maybe the plaintiff moved to Connecticut. The plaintiff was only 24 years old, by the way, a young guy. Yeah, and I know the plaintiff's attorney very well. I've also worked with cases on him before, with him before. We've partnered on some cases. He's an excellent attorney. Let's go back to by date and see what's most recent and see if there's anything interesting in the recent ones. So we had the defense verdict. We had the 2.95. That was recent. Well, here's actually, this one is recent and it's 22 million, 22.9 million. It's recent. There's also a 4 million recent one with an ambulette driver. Let's do the ambulette first. The ambulette, basically, it happened in New York state, but also Kings County, which is also Brooklyn. What happened here was that the plaintiff was 49. He was a home health aide, and he was a passenger in an ambulette that was traveling on Avenue I in Brooklyn near Ocean Parkway. And he alleged that the ambulette driver stopped suddenly and caused him to fly forward into the dashboard. And he claimed neck, shoulder, and back injuries. So he sued, of course, the ambulette, the owner, and the operator, and he alleged they were negligent. And he had an accident reconstruction expert testify that the ambulette operator's reckless driving caused the crash. And according to the expert, the ambulette driver rapidly attempted to move into the adjacent left lane, but did not have room to do so because there was a construction van in that lane. So the plaintiff alleged that the ambulette driver that made a short and aggressive stop to avoid the collision. And as a result, the expert concluded that the plaintiff, he was propelled forward into this dashboard. He was injured. And so the plaintiff, his name was Gayan. She testified that she was unable to locate a seatbelt when she initially entered the ambulette. That's why she was unrestrained. And so the defendant maintained that the ambulette was not negligent because there was no accident. There was no actual crash, right? He just avoided this. He tried to get into a lane, but there's a construction van. So he's like, oh, wow, I have to either stop short or get out of this lane. And so just that sudden maneuver caused the unrestrained home health aide sitting in the ambulette with her patient, caused her to fly forward into the dashboard. But there's no crash. We didn't hit anything. That was the defense argument. And the defense noted that there was no impact between the vehicles, no injury complaints communicated at the scene, and no police ambulance report written. So the plaintiff ultimately was diagnosed with C4, C5, C5, C6, and L2, L3 herniations, a bunch of bulges, also a slap tear and impingement of the right dominant shoulder, and began a course of physical therapy that lasted for the next year, received trigger point injections, and then had an anterior cervical discectomy infusion at C5, C6, and C6, C7. Wow, so this is exactly the same as the case we just did for 27 million, exactly the same surgery. And then also had a back surgery that included medial fascectomies, facetectomies, that's the facet joints in the back, and a discectomy and a fusion. So yeah, the facet joints are basically like little circles where the nerves come out. So when you look at the spine, the circles made out of bone. They're part of the spinal cord and the spine itself, just like the vertebrae are made of bone, the facet joints are made of bone, like cancellous tissue. And so the nerves come out, and actually near the facet joints is where you have the actual nerve centers, like the ones that I think they're called basal ganglia. They're thicker, they're round. That's where all the nerves kind of converge. It's like the control center of the nerves. It's a very important place. And then the nerves kind of branch out almost like a tree, and they become smaller branches. So so they had that. Also had an arthroscopic shoulder surgery, and then 2 revision lumbar surgeries, physical therapy. She was diagnosed with unrelated Parkinson's disease and had to be on a cane. And then a spinal surgeon testified that the accident caused permanent disabling injuries. And then the plaintiff's attorney argued that the treatment will cost $168,000 every year in the future because she's going to require physical therapy, injections, imaging studies, and orthopedic follow-ups. And that's going to cost $168,000 just in costs for this care for the future. And she was, let me see if it says how old she was. Oh yeah, we said 49. So yeah, 49, I mean, people live to be 83. So you're talking about about 30 something more years. And then basically the plaintiff also had a vocational rehabilitation expert, and he or she gave the opinion that plaintiff's disabling injuries preclude her from working. And then she sought recovery of past and future medical expenses, $553,000 in past and future lost wages, lost salary or earnings, and also sought recovery of damages for past and future pain and suffering. And the defense's spinal surgery expert testified that the plaintiff's injuries were degenerative conditions typical for someone her age, 49, and attributed all of the injuries and complaints to the Parkinson's disease. It's just kind of weird, right? Because you get into a car crash, you get diagnosed with these injuries, you have surgery, and then while you're waiting for the trial, after the crash, just get diagnosed with, Parkinson's disease, right? It could be anything, it could be cancer. But then the defendants took that and said, all these injuries are from the Parkinson's, not from the crash. So I don't know, that's kind of a low blow by the defense, but that's an interesting defense. And so the defense's orthopedic surgery expert testified that the plaintiff's shoulder impingement was pre-existing and that she was receiving treatment for this injury at the time of the supposed accident. And the expert further opined that the plaintiff did not sustain a slap tear. So yeah, basically they're saying everything. It's a typical thing, right? Everything's degenerative, everything's from living your life, the normal painless aging process, and the plaintiff says, no, it's all from this crash. So the jury determined that the Ambulette company was negligent and that its negligence was a factual cause of injury to the plaintiff, and the jury awarded the plaintiff $4.292 million. So it was $640,000 for past and future medical costs, $1.3 million for past and future lost wages, $2.28 million for past and future pain and suffering, and so the total was $4.292,000. That's a pretty good result, $4 million. But the only part of it that I thought was kind of odd was like $2 million for past and future. Like we just did the other case, that was like 27. I mean, I guess 27 is a little bit of an outlier. That's a big verdict, and they might not pay something like that. They'll probably appeal, and then the appeal will take another 5 years, But so this trial, by the way, lasted 12 days. The jury deliberated for 3 hours. It was a 6-0 vote, meaning all the jurors agreed. There were 2 men and 4 women on the jury. Okay, let's do one more case. So it's another bus passenger, and this time the bus passenger claimed multiple injuries after a truck collision. So what happened here, it was also Brooklyn. Wow, a lot of these cases are Brooklyn. What happened was here, it was December of 2023. That's when the verdict came down. But it was a woman also. Her name was, I believe, Quinn, and she was 37 years old. And I know the law firm for the defendants. I've done, the trial I did where we settled in the Bronx for $3.5 million during trial was actually the same law firm. So this was a law firm for the defense. And, and they had this orthopedic surgery expert who's a really known expert who's kind of like very, very much an advocate for the defendant. See, when you get like an expert who's such an advocate, who's not independent, who's not a real like expert that looks at both positions and is real, kind of like almost biased, and you have like this history, all these transcripts, it's like he has all these skeletons in his closet. It's not good for the defense. So let's see what happened. So this crash happened in 2018 in January. Quinn was 37. She was a public health assistant. She was a passenger on a New York City Transit Authority bus. The front of the bus struck the side of a New York City Department sanitation truck. So that's interesting. The bus crashes into the sanitation truck. And she claimed injuries to her neck, back. And then she sued the bus driver and the truck driver. And she also sued the city of New York, as well as the New York City Transit Authority. And she alleged the drivers were negligent in the operation of their vehicle. She also claimed the New York City Transit Authority was vicariously liable, like we talked about. So a lot of these cases, you see common themes, like the course and scope of the employment, vicarious liability. And so there was a traffic light at the intersection. According to court records, the video from the scene confirmed the bus driver ran the red light and drove her bus into the side of the garbage truck. And so the court granted the city of New York's motion for summary judgment. So that's the motion, not of the plaintiff, but of the garbage truck, right? Because if you have a video and the video shows, hey, this bus just blew a red light and crashed into the side of a garbage truck, what did the garbage truck do wrong? It's just driving with a green light, or it stopped with a green light, whatever it may be, they're not at fault. And so there's no way a jury could say that this garbage truck owned by the city of New York. It's a New York City sanitation truck that it had any liability, even 1%, right? So they let them out of the case. And so the case went to damages against the transit authority, against the bus. And so the injury was that this lady was transported to Jamaica Hospital. She was discharged a few hours later, treated and released. She was diagnosed with C3, C4 herniation, C5, C6 bulges, cervical spasms, and then she had an L5, S1 herniation and lumbar radiculopathy. She claimed tears to the labrum, rotator cuff, and subscapularis tendon in her left shoulder. She alleged the left shoulder derangement, impingement, tendinosis, and diffusion as well. And she claimed derangement of her right shoulder and knee. She claimed post-concussion syndrome with associated headaches and dizziness, and she also alleged sprains and strains to her neck, back, shoulders, and knees. And she received 6 months of physical therapy following the crash. She also underwent neck surgery. The 2-level anterior cervical discectomy and fusion included arthrodesis and a partial corpectomy. And for her shoulder, she received a steroid injection, and then she had arthroscopic shoulder surgery that included debridement and a subacromial bursectomy. The bursa is like a little bubble there, like a little pad, so you don't get inflammation when you move. And so a bursectomy is like where they have to shave that down because the pad gets impinged, the bursa. And a debridement is where they shave down a bunch of stuff. So it's the same thing, right? It's kind of similar, arthroscopic. And so she also underwent a lumbar hemilaminectomy and received epidural injections. And the plaintiff's attorney argued that all of her surgeries were causally related to the crash. She said that her injuries left her with post-traumatic arthritis and reduced her range of motion, and she never returned to work. And she sought recovery of future medical expenses, past and future lost wages, and past and future pain and suffering. Now, the defense argued that she did not suffer a serious injury as defined in the no-fault law, 5102D. The defense specifically argued that the force of the impact could not have caused, Quinn's injuries. That the defendant's medical expert opined that at her worst, sustained soft tissue injuries, and that they resolved in a month. That's like the worst that could have happened, because I guess it was like a small crash. Maybe the bus driver ran the red light and at slow speed, maybe 10, 15 miles an hour, crashed into the side of the sanitation truck. And as a passenger on that truck, the defense said, look, the most you could have gotten was some soft tissue injuries that went away in a month. And so the expert concluded that Quinn's surgeries were not medically necessary, and he based the opinion on the medical records and the alleged lack of traumatic injuries visible on her MRIs. And the expert added that her surgeries ultimately made her injuries worse. Also, he actually blamed the treating doctors for doing the surgery. He said if you didn't do the surgery, she would have been okay. But the fact that you did these surgeries, that's what made it all worse. So what did the jury do? Let's see. The jury determined that Quinn did not sustain a permanent consequential limitation or use of a body, organ, or member. However, the jury decided that she did sustain a significant limitation or use of a body function or system. So they said the injury is not permanent, but the injury is significant, and it does limit, a body, like we talked about, like the neck is a body function or system, and it did limit it in a significant way. And significant just means like more than, not trivial, right? Not like insignificant, not frivolous or trivial, that it's something serious, something meaningful. And so anyway, the jury awarded $22,985,000. That's pretty good, almost $23 million. So it was broken down as $210,000 past lost earnings, $2.4 million past pain and suffering, $14 million future pain and suffering for 38 years. She's 37, and the jury said according to the averages, she's gonna have this pain and suffering for 38 future years. $5.5 million for future medical expenses, also for 38 years, $875,000 for future lost earnings for 25 years, and so the total was $22,985,000. The trial lasted 4 weeks. The jury deliberated for 3 days. They thought about this for 3 days. That's a long time. And it was 3-3 on permanent consequential, right? That's the one where they said, no, it's not permanent. They were deadlocked. 3 people thought it was permanent, 3 thought it wasn't. So they were deadlocked on that. It was 5-1 on future pain and suffering and future medical expense awards. And it was 6-0 on significant limitation. So they all agreed she had a significant limitation. But the past pain and suffering award and the past and future lost earnings awards. Those were all 6-0, 5-1 on the future pain and suffering. The future pain and suffering was 14 million. So I guess one person didn't want to give 14 million, probably wanted to give maybe less, I'm guessing. And the judge, actually I know this judge, this was the same judge that was my trial judge when I did my trial where I got the 535,000 for a young girl who got cut and had the complex regional pain syndrome, the CRPS, that I did in February of 2023. This was the same judge. She's a good judge. She's very smart. A little bit strict with all small stuff. Like she's like, oh, don't speak to me unless you stand up. Or, you know, at one point she asked us to research something. So I was looking on my cell phone because I had like Westlaw open. I had the case and she's like, counselor, don't look at your phone in court. You know, so she's a little bit like, it's tough with that small stuff, but she's a very good and smart judge overall. So thumbs up. But yeah, great results. So this is just a sampling of some of these results. So please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. If you need a consultation, just text me 347-566-9595. I'm happy to provide a free confidential consultation. And that's about it. Okay, everyone. Bye-bye. Have a great day.